Maybe they turned 7, so that was 7 years ago.
Court will come to order.
All right, thank you. Let's go ahead and get it done.
Already on it, Joe.
All right, the defendant is present once again. State, call your next witness.
Stacie Brenner, Your Honor.
All right, and Ms. Brenner is appearing via Zoom and video and audio, if we can see her. I'll go ahead and have Ms. Brenner raise the right hand and be sworn, please.
Do you solemnly swear or affirm that the testimony you shall give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Thank you. And can we go to the bailiffs to tilt the camera back towards the podium so that the witness can see at least?
Judge, I do have mark for identification of states K. This is the cell phone map demonstration. I move it into evidence as the next
Very
court exhibit.
State's Exhibit 10, Judge.
Actually, it's okay, just leave it at, we'll get it as evidence. Just to let Mr. Shea know, Mr. Shea, I had asked the state to put that mapping thing that they did with the last witness in evidence for purposes of the hearing only, and it's become evidence number 10.
Yes.
Give me 1 second. Okay, let's go ahead and proceed.
Yes, Your Honor. Just keep them clean.
Oh, no, okay.
Yeah, Ms. Bryant, can you see the state? Yes.
I think so.
Okay, if you want to get closer, maybe she can see you a little better. I don't know that it's necessary, but I think it's more important that she hear you.
Yes, Judge.
Yeah,
That's
the
the
microphone
right
is right there. If you want to sit at the witness stand, that may be even, you know,
One of my first time, Judge.
all right.
And so the court knows Mr. Shea has the court copies, but I'm going to enter copies of the live reports into evidence related to these witnesses.
Unless the court would like to have it.
Wait, no, that's fine. So they get put in evidence, I'll look at them later.
Good morning, Ms. Brenner.
Good morning.
You hear me okay?
Yes.
Ms. Brenner, just so you know, as we're going through your testimony here, we're going to be able to skip over some portions since this is a pretrial evidentiary hearing. We don't have to cover a lot of the background questions about what is DNA, how it works, things of that nature. So we'll be going a little faster today, okay?
Okay.
Could you please state and spell your entire name for the court reporter?
My name is Stacie Brenner, Stacie Brenner.
And Ms. Brenner, where do you work?
I work in the forensic biology unit at the Palm Beach County Sheriff's Office.
And what is your current position in the forensic biology unit, ma'am?
I am a senior forensic scientist.
And what are your duties on a day-to-day basis?
As a senior forensic scientist, I am involved with generating DNA profiles, and as a DNA analyst, I will generate these profiles, make comparisons of evidence to known profiles. I'm also responsible for testing biological fluids such as blood and semen, and I will write reports to any findings that I have in the laboratory and often testify to these findings. I also may be involved with validations of new instrumentation or software programs in the laboratory.
And Ms. Brenner, could you briefly describe your educational background for the court?
Sure. I have a Bachelor of Science with a concentration in forensic science from Cedar Crest College in Allentown, Pennsylvania. And I also have a Master's of Forensic Science, also from Cedar Crest College.
And what type of training do you have in DNA analysis?
Besides my education, at the Palm Beach County Sheriff's Office, I have underwent approximately year-long training program before I became a DNA analyst. And the training program consisted of laboratory demonstrations, lectures by trained individuals and qualified individuals, a lot of literature, reading of current literature, as well as testing several types of mock case samples, and then performing a competency exam as well as a mock trial to complete my training.
And Ms. Brenner, how do you stay stay current in your field? I'm sorry.
In the forensic biology unit, we have journal clubs, also known as like a literature review, where we stay current with the literature in the field. I'm also involved in going to conferences, whether they be virtual or in person, where the scientific community gathers and discusses the current technologies and implementations in the field.
And does your agency have proficiency testing?
Yes, it does.
Can you describe for the court what that is and how it works?
A proficiency test is a test administered by an outside company or agency, and this is done in order to ensure the analyst can produce accurate and reliable results following the correct protocols and procedures. And as a DNA analyst, I am proficiency tested twice a year.
And have you ever testified in court as an expert in your field or in this field before?
Yes, I have.
Approximately how many times?
Probably about 50 times.
Your Honor, at this time, I'd request from the court that she be allowed to render an opinion as to DNA testing and analysis in this case.
Okay, she can express an opinion based upon her qualifications, unless you want to voir dire.
No objection.
All right, very well, you may proceed.
Ms. Brenner, did you do any testing in relation to the murder of an individual by the name of Rachel Bay? Specifically, agency, I'll give you the case number 16-047704.
Yes, I have authored 2 reports in regards to that PBSO case number.
Very good. Let's go through the first of those reports if we can. And you have that first report in front of you?
Yes, I have the report that's dated November 28th, 2016.
And in that report, what submissions did you receive for testing?
I've received a submission titled Sexual Battery Evidence Collection Kit from Rachel Bay. And this submission contained various other items. Would you like me to list all of the items?
No, just the general submissions is fine.
Okay. And then I also received submission 3, which was titled 2 Blood Standards from Rachel Bay. Submission 6, which were swabs from Rachel Bay, which included swabs of the hands and forearms. And then submission 7, which included other swabs from Rachel Bay. They were just separated as a separate submission. And submission 8 were hair standards and fingernail clippings from Rachel Bay. And submission 17, which was 2 oral standards from Jose Gonzalez.
I want to talk to you in particular about submission 2A, the genital swabs.
Okay.
Did you perform DNA testing and analysis on these items, on the genital swabs, item 2 or submission 2A?
Yes, something called a differential extraction was performed on this sample. And what this does is separates epithelial cells or skin cells from sperm cells. And because of this, there are actually two results. So there is a result for the non-sperm fraction or the epithelial cell fraction, and then a result for the sperm fraction.
And what were those results?
The results for the non-sperm fraction indicated that the amount of female DNA was, compared to the amount of male DNA, was over a point where the sample could be processed just with Y STRs. And the reason for this was, if the sample was processed with autosomal STRs, then the sample would yield most likely only a female profile. But since there was an indication that there was male DNA, this sample was forwarded directly to YSTR analysis, which would look directly at just the male DNA. So that sample actually wasn't processed for autosomal STRs. And the sperm fraction indicated the presence of two individuals, where the major profile was consistent with Rachel Bay, and a male contributor was determined to be this part of the mixture, and Jose Gonzalez was excluded as a contributor to the mixture.
Did you have sufficient data to make a comparison to Jose Gonzalez, or would you have sufficient data to make a comparison to any known sample?
Yes, for the second contributor in that profile, that's correct.
And again, that was from the sperm cell fraction, correct?
Correct.
I want to move then to, let me ask you first, was that item entered into CODIS? The male profile?
Yes, as part of my processing, the foreign profile from the sperm fraction was entered into CODIS at that time.
I do want to talk about swabs 7D and E. The swabs from the right ankle and the left ankle.
So the result for 7D, the swabs from the right ankle, indicated the presence of two individuals, and the major profile was consistent with the DNA profile obtained from Rachel Bay, and the minor profile was determined to be of no comparative value due to dropout of the profile. However, in the report, it also states a male contributor to the mixture was obtained, and this is because male DNA was seen in the resulting profile at the sex marker, amelogenin. However, no comparisons were actually made to that second contributor.
Is that because there was insufficient data for a comparison?
That's correct.
And was it the same results for item 7E, the swabs from the left ankle?
Yes, that's correct. The only difference with 7E is that the profile was determined to indicate at least two individuals.
But still not sufficient data to make a comparison?
For the minor contributor, that's correct.
Yes, the minor contributor.
Correct.
I want to move now to the second report you issued.
What's the date of the second report?
Ma'am, what is the date of your second report?
The second report was dated April 28th, 2017.
And was this dealing with the same submissions, but additional testing that you were doing on these submissions?
The first report may have listed the submissions, but I don't think they were actually analyzed. And then in this report, additional evidence that was originally listed was then processed.
Okay. And does that include submission 6 and the several sub-submissions from submission 6, the swabs from Rachel Bay?
Yes, that's correct.
I want to talk to you about submission 6C. What submission was that?
That's swabs from top of left hand.
And were you able to get through your testing and analysis a DNA profile, a mixed DNA profile?
Yes, the profile was generated and indicated the presence of 3 individuals.
Were the 3 individuals suitable for comparison, or could you make a comparison with a known profile to those 3 individuals?
Yes, and the individual Rachel Bay could not be excluded from the mixture, and a male contributor was obtained in this mixture.
So if you had a known sample from a male, you could make a comparison to the male contributor to that sample.
Yes, that's correct.
And did you recover any other results in regard to this report that was suitable for comparison?
In regards to the other samples tested?
Yes, ma'am.
The other samples tested, which include the right breast swabs, left breast swabs, swabs from top of right hand, swabs from palm of right hand, and swabs from palm of left hand, swabs from palm of left forearm and right forearm, were all mixture samples, and the minor profile was not of comparative value.
Let me ask you this about the 2. So talking about the foreign male DNA you recovered in the first report and the foreign male DNA recovered in the second report, could you tell whether or not those profiles were consistent with one another?
Yes. So one of the individuals that was contributing to swabs from the top of left hand in submission 6C was similar to the foreign profile that was put into CODIS from the sperm fraction of 2A. And at this point, at this report, the sperm fraction was actually removed from CODIS, and the foreign profile from this sample, 6C, was entered into CODIS because this profile was consistent and also was of better value. So there was more information.
So you wanted to have the profile that was in CODIS that had more information for potential matches.
That's correct.
And when you say consistent, we talked with FDLE about this, but what does consistent mean when you're talking about 2 profiles?
This would indicate that that individual, if there was an individual, they would not be excluded when comparing to those profiles.
And other than these 2 reports, you didn't author any other reports in relation to this investigation, did you?
No, I did not.
Thank you, ma'am. I don't have any further questions. I'm going to tender you to the defense attorney to see if he has any questions.
All right. Any further examination for Shay?
You can take my seat, Mr. Shea, if you'd like. You want my copies?
Good morning, Ms. Brenner.
Good morning.
Going up to your report on September 16, 2019. And I'm looking at the submission swab from the left hand. And you indicated there were 3 contributors, is that correct?
I apologize. Which report are you referring to?
I think you used the wrong date.
This is what I have here.
She issued 2 reports. One was
I think that's a summary report.
April 28th, and the other one was April 28th. And then the other one was November 28th of 2016.
Yeah, no,
This report is oh, you looked at, I think it might have been the date it was printed. Oh, this is not this witness. This is a different witness. This is the next witness, I think.
Oh, okay, this was handed.
That report belongs to the next witness.
Okay, thank you. One moment, I'm reviewing my notes. For the purposes of this hearing, I have no further questions.
All right, thank you. Anything else with this witness?
There you are. I believe our next witness is already on there.
All right, thank you. Let me excuse this particular witness. This is Ms. Brenner. Ms. Brenner, you're free to leave now. And
Thank you.
take state's next witness.
Yeah, that's gonna be Miss Sowards.
Okay, and then I believe she's on. Can you unmute yourself, man? We cannot hear you.
Can you hear me now?
You can now.
Okay.
If you will raise your right hand and be sworn, please.
Do you solemnly swear or affirm that the testimony you shall give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, Miss Sowards.
Morning.
Could you please state
Hold
your,
on, we got a really bad connection. Can you speak again?
Good morning.
Okay, all right, we'll give it a try.
can you state your entire name and for your name, better spell the whole thing for the court reporter?
Sure. Celynda Sowards. My first name is Celynda. Last name is Sowards.
We're gonna have a very bad connection here. Ms. Sowards, do you have a telephone number we can call you?
Just 1 second. Let me try something on my end, if that's okay.
It sounds scratchy and I don't really know what the issue is.
Sounds like she's got a lot of reverb.
Is this any better?
There's some sort of a background noise that comes up whenever you speak. You want to just hang up and then try again? Maybe we'll get a better connection.
Sure can.
Did you have a phone number for her? His phone works much better.
I think we do.
Okay. Try again here.
Yeah, can you read something for me?
My name is Celynda Sowards. I work at the Palm Beach County Sheriff's Office.
You okay with that? Or you rather have it?
I'd rather have the phone.
You rather have a phone? Okay, if you can maybe communicate with the state attorney's office, we're gonna call you. She's already been sworn, so I have no issue with that. Maybe we can call you on a telephone and then you can leave the camera on if you like, but mute it so we can get feedback, and then we'll just call you on the telephone.
Sure.
and get a little better sound from you.
Okay.
Just stand by while we get that number.
This is Celynda.
Okay, can you hear us?
Yes, I can.
Now you need to mute your computer so we don't get feedback.
How's that?
That's much better. Does that work for you, Holly?
Yes.
All right, if you can't hear counsel, let me know, okay?
Okay.
Thank you, Judge. Can you hear me, Ms. Sowards?
Yes, I can.
Ms. Sowards, where do you work?
I work at the Palm Beach County Sheriff's Office Crime Laboratory in the Forensic Biology Unit.
How long have you worked there, ma'am?
I have worked here at PDSO for almost 15 years.
And what is your current position in the biology unit?
I am a casework supervisor.
And what are your duties on a day-to-day basis, ma'am?
On a day-to-day basis, I do analyze DNA evidence, make comparisons, write reports to my findings. I do testify in court. In addition, I oversee the in-house casework flow in the laboratory.
And can you briefly describe your educational background for the court?
Sure. I have a bachelor's degree in chemistry with an emphasis in criminalistics from the Metropolitan State College of Denver. And I have a master's degree from the University of Florida in forensic serology and DNA.
In addition to your educational background, what other types of training do you have in DNA analysis?
I have extensive training that I have undergone here at PDSO that encompasses everything from the receipt of evidence, how to handle it, conducting DNA, writing reports. In addition to the in-house training that I have received here at this agency, I also am required to undergo external training for at least 8 hours every year.
And do you have training in statistics and statistical analysis of DNA evidence?
Yes.
And what's that training?
I underwent the statistical analysis training here at PDSO prior to coming online with DNA analysis casework. And since then, we have changed statistical methods. So I have undergone training in that methodology as well.
And we just heard from one of your colleagues, your agency has proficiency testing, isn't that right?
Yes.
And do you participate in that proficiency testing?
Yes, I do.
And have you ever testified as an expert in the field of DNA identification and analysis?
Yes.
How many times?
In DNA, in a trial, over 70 times, I think, 60 to 70 times.
Your Honor, based upon her training, her experience, her educational background, and her qualifications, I ask that she be allowed to tender an opinion.
Okay, she'll be allowed to express an opinion unless you want to voir dire her.
No, Your Honor, I have no objection.
Okay, very well, you may proceed.
And Ms. Sowards, we're going to skip by a bunch of questions. Fortunately, without a jury, we don't have to go into every aspect of explaining what DNA is to the court. So I'm going to jump right into the report you authored in this case. How many reports did you author, ma'am?
I authored 3 reports in this case.
The report I want to talk to you about, I believe, is dated, I can get the date right, is it September 16th of 2019?
Yes, that is the first one I authored in this case.
And is that report, does that report include submissions from Rachel Bay?
Yes.
And for those submissions from Rachel Bay, had they been previously tested by one of your colleagues?
Yes.
And was that colleague Ms. Brenner, who we just heard from?
Yes.
And did you also receive a submission from a Robert Tyrone Hayes?
Yes.
And what submission number was that?
That is submission number 31.
Were you able to get a complete profile from submission 31?
I believe so, but if I could check my paperwork.
Yes, please.
Yes, I did.
And were you able to compare the complete profile from item 31, the oral standard from Robert Hayes, to any of the findings from your colleague?
Yes.
And let's talk first about submission 2A, the genital swabs. Were you able to make that comparison?
Yes, I did.
And what were the results of your comparison of the oral standard from Robert Tyrone Hayes to that profile, or the mixed profile previously located by Ms. Brenner?
That he could not be excluded as a contributor.
And were you able to perform a statistical analysis in relation to your results?
Yes, I did.
Could you tell the court what your statistical analysis revealed in regard to the likelihood that he was a contributor to that mixed profile?
Yes, and I would like to request that I read the entire statistical statement directly from my report as it is long.
That's fine, ma'am.
Okay. The DNA profile obtained is approximately 2,290,000,000,000,000 times more likely if it originated from Rachel Bay and Robert Tyrone Hayes than if the DNA profile originated from Rachel Bay and an unknown individual in the population. This statistical result provides very strong support for the proposition that Rachel Bay and Robert Tyrone Hayes are contributors to the DNA mixture.
And in your agency, in your field, what does very strong support mean?
We do have a verbal scale to try and put some kind of weight and understanding to the numerical value of the actual statistic that is provided. And we utilize the SWIG-DAM or the Scientific Working Group for DNA Analysis Method. We utilize the SWIG-DAM verbal scale in our report. And the top of the range is very strong support. So once we reach the very strong support area, there is nothing beyond that.
And in your report, I know you said quadrillion. Is your report, do you have a mathematical abbreviation for that number in your report?
Yes, so the number that I verbally stated just now is shown in my report as 2.29 E15. And what that E15 means is that is a way of denoting scientific notation. So if you ever learn scientific notation, it's traditionally taught as 10 to the X power. In this case, it would be 15. So this would be written traditionally scientific notation as 2.29 times times 10 to the 15th power. So the E takes place of that 10 to the.
Thank you, ma'am. I want to move next to the swab submission 6C, swabs from the top of the left hand.
Okay.
Were you able to make a comparison to that mixed profile previously located by your predecessor, or by your colleague, I'm sorry?
I did.
And what were the results of your analysis and comparison when looking at Mr. Tyrone Hayes's known sample to that mixed profile from Rachel Bay?
That Robert Tyrone Hayes could not be excluded as a contributor.
And was there sufficient data to make a statistical analysis of that information?
Yes.
And would you like to read can you read your statistical results to the judge?
Yes. Reading directly from my report, it's going to be that same long statement again. The DNA profile obtained is approximately 1,340 sextillion times more likely if it originated from Rachel Bay, Tyrone Hayes, and an unknown individual than if the DNA profile originated from Rachel Bay and two unknown individuals in the population. This statistical result provides very strong support for the proposition that Rachel Bay and Robert Tyrone Hayes are contributors to the DNA mixture.
So it falls within the same scale as the last examination, last statistical result.
That is correct.
And finally, I want to talk to you about a report done by one of your colleagues. This is a report that is dated think it's 9/17 of 2019 by analyst Stacie Anderson.
Okay.
Do you have that report?
I actually don't have it in front of me.
Do you recall speaking to me about a report and testing done by Stacie Anderson on a submission from a John Barfield?
I can get access to it on my computer if you would like me to pull it up.
Please, if you can.
Celynda. I have it in my phone for I can do this. Why is happening?
Well, stand by. We have somebody who unmuted themselves and is interrupting. Is there Tiffany Roy, whoever you are, you need to mute yourself, or I'm gonna exclude you from the Zoom. Okay, you may proceed.
Thank you, Your Honor.
I just pulled up Stacie Anderson's report from September 17th, 2019.
Yes, and in that report, is there a submission 29, a Zephyr Hills water bottle from John Dion Barfield?
Yes, that is listed on the report.
And did Ms. Anderson make comparisons between a profile she acquired from that water bottle to the items we were speaking about earlier, the swabs from the top of the victim's left hand and the swabs, the genital swabs?
Yes, she did.
And let's start with the genital swabs. What was the result of her analysis in regards to that comparison?
According to the report that she authored, John Dion Barfield is excluded from contributors 1 and 2 from the profile obtained from the genital swabs.
And same question for item 6C, the swabs from the top of the left hand. What were the results of her comparison there?
John Dion Barfield was excluded from the profile obtained from the swabs from the top of the left hand.
I just have one moment, Your Honor.
Yeah.
Ma'am, that's all the questions I have for you. I'm going to tender you to the defense attorney.
Okay, any cross-examination?
Yes.
Did you say you admitted the item, you're gonna put the items into evidence, or you did?
I'm going to put all 4 of these live reports that we've talked about today.
Okay.
Are you familiar with Stacie Anderson's work and the quality of work that she does?
Yes, I am.
There were some questions asked of her in relevance to sperm. Is it correct to say that a bacteria eats up a tail first when you're analyzing the sperm?
I'm sorry, can you speak up just a little bit, please?
Actually, if you can just
Oh, I'm sorry.
face a little bit this way or get closer to that microphone, she might be able to hear you.
Yes, sir. I was trying to
Thank
answer.
you.
During her analysis, she made some statements, of course, that in examining a sperm, that bacteria eats up the tail first. And so when they also check and they get their DNA results from the sperm heads, would that be a correct statement?
Yes,
And does that give any indication as to how long the sperm may have been present before it was collected?
I would not be able to state how the sperm got in a particular location.
Well, let's go back to your report, if we may.
The September 16th report.
Yes, ma'am, the one you were just testifying about. You indicate that submission 6C, swabs from the top of the left hand, showed there were 3 contributors. Is that correct?
The number of contributors was previously determined by the analyst who conducted the testing on that item.
And that analyst was, I believe, Stacie Anderson. Is that correct?
I believe that was Stacie Brenner. I don't have those reports or that paperwork in front of me, but I believe it was done by Stacie Brenner.
Did you review the reports done by Stacie Anderson in any of the summations that you made in this report? Not
that I recall. I may have looked at them briefly, but I don't recall at this point what any of them say, except for the one that I just read from.
Can we confer with Mr. Shea?
You want to confer with it? Yeah,
Yeah.
yeah, Mr. Shea, if you
I
want
think
to.
there's some confusion about the reports between the 2 different Stacie analysts.
Yeah, and I think I might have contributed to the confusion because he had this lab analyst's report in hand when Stacie Brenner was testifying, and he tried to ask that question of Ms. Brenner, and I told him that the report belonged to this particular witness, not the other one. I think I was the source of the confusion.
He did have the wrong report, but I think the questions he wishes to ask now were for Ms. Brenner. Is it possible to recall Ms. Brenner? I think that may be necessary.
See if we can reach her out, Yeah, you want to talk to him?
Yeah.
Yes.
Ms. Anthony, is there any, and Mr. Vanek, is there any possibility that she can testify as to Ms. Brenner's report? I mean, it's a matter of record, what's in the report. If she can take a look at the record and either confirm or deny it based upon the report, I don't know if she has access to that report. Might say it was a little bit of time, but I think the question is whether or not in the submission from the top of the hand, there was 3 contributors as opposed to 2. I think that's a point he's trying to make. And apparently, according to this witness, that analysis was done by Ms. Brenner, not by her. So I don't know if you want to ask her that.
That's absolutely correct, Your Honor.
And Judge, that's, I mean, I'll stipulate that's in the report that I'm gonna to introduce.
Yeah, but it's fair enough that he wants to get it on the record. I don't have a problem with that. I think he's entitled to do that. So I don't know if she can confirm that or whether we want to get Ms. Brenner on the line.
Ms. Sowards, can you access that report from Ms. Brenner?
Yes, I can. Can you give me the date, please?
Yes.
Was it the 4/28/17 report?
Yes, that's correct.
And it has to do with the swab from the top of the left hand.
It's 6C, I think.
Thank you. Stacie Brenner's report from 4/28/17 does state a DNA profile was obtained from submission 6C and indicates the presence of 3 individuals.
And in the report, is it correct? It says that Tyrone Hayes cannot be excluded, including the contributor number 2 cannot be excluded, who's unidentified.
That's what my report says.
Does the report also indicate that that analysis is based on the fact that she attributes 4% of the DNA as coming from Mr. Hayes and the exact 4% coming from the unknown contributor?
Can you tell me where those numbers are in the report?
Well, I'm looking at at the deposition here. So unfortunately, I don't have that.
Yeah, it's an answer she gave in the depot according to the attorney, so we might have to get Ms. Brenner
Yes, Judge.
on the phone.
Yeah, I don't see those numbers in the report, so that may have been in the actual paperwork that she has. But to my knowledge, again, without having any of the paperwork in front of me, to my knowledge, Stacie Brenner performed the DNA analysis and determined the number of contributors. And then with regard to the contributor ratios, that may have been done by Stacie Anderson.
That's correct.
Okay.
I'm good with that answer.
Okay, it gets more confusing.
Yes, sir.
Two Stacy's. All right.
I have no further
No
questions.
further questions? All right, any,
Wait, before the witness is excused, let me confirm with Mr. Sugar.
yeah,
Your Honor, with permission of the court, with the state, I would like to ask Ms. Sowards some questions about the genetic genealogy investigation.
Similar to the prior questions.
I'm gonna let him.
That's fine, Judge.
Okay, go ahead. Ms. Sowards, you're gonna have a different attorney ask you some different questions now, okay?
Okay.
If you don't mind coming up here, it makes it a little easier for,
Yeah, just stand here.
you can, if you like.
Ms. Sowards, just wanted to ask some questions to clarify the role of the Palm Beach County Sheriff's Office Crime Lab in the genetic genealogy investigation that took place regarding the homicide, in connection with the homicide investigations for the Daytona homicides. All right?
Okay, I'm not sure how much of that I can answer. To my
Okay.
knowledge, I came in kind of after a lot of that took place. I'll try and answer what I can for you.
Okay. Well, suffice it to say, from your review, from your familiarity with this particular case file, the Rachel Bay homicide and the work that the crime lab did in Rachel Bay's homicide, it was not a sample from Rachel Bay that was used to develop the genetic family tree, to develop a genetic family tree of this unknown male contributor. Isn't that right?
I don't know. I don't know what sample was sent out for the analysis.
Okay. There's two different types of analysis, generally speaking, between the normal course of identity testing in criminal cases versus the genetic family tree that's done sort of privately and commercially by average citizens, right?
To my knowledge, yes. I don't really want to speak too much about it because I don't feel like I have the expertise to be able to do that. I just know that we don't do it in our laboratory because we do lack a lot of we lack the foundation and the materials to be able to do it.
Okay, and just what I was just getting at briefly is crime lab DNA identity testing is usually STR based, right?
Correct. There are some labs that do mitochondrial DNA. We are not one of them, but yes, traditionally, most, I would say even government labs revolve around STR testing.
And then the genetic family tree DNA profiles are developed with SNP, which is referred to as SNP, SNP types of testing, correct?
To my knowledge, that is the case.
And you don't do SNP testing at the Palm Beach County Crime Lab, correct?
Correct.
And from your review of the case file, you don't see that it was any sample collected from any of the swabs of Rachel Bay that was used to develop a SNP profile, do you?
I don't know what sample was sent. I just know that we don't do that here in the laboratory, and a lot of that analysis and work with that was done prior to me becoming involved in the case.
Okay, would that be something that Stacie Brenner would know?
I would say probably so. I would say that either Stacie Brenner or Stacie Anderson would have more information, more likely Stacie Brenner.
Okay.
But I don't have any information. I was not involved in that portion.
Okay. And you wouldn't be able to answer questions about the lead that was developed from the genealogy investigation?
No, I would not.
Okay. All right. Thank you.
Thank you. Anything else, Steve?
Not for this witness, Your Honor.
Okay, anything else, Mr. Shea?
No, Your Honor.
Thank you so much and have a good weekend, Ms. Howard.
Thank you for your accommodation.
Bye-bye. All right, anything else we want to do on this?
Assistant manager.
Yes, Judge.
Just read it.
I'm going to move into evidence at this time. What's been marked for identification of states J, and this is the 4 laboratory reports we were discussing this morning with Palm Beach County.
As a composite exhibit?
Yes, Your Honor.
Okay.
No objection.
And the clerk is marking now the state's last exhibit, and those are the FDLE laboratory reports that were discussed yesterday during the live testimony. I move those into evidence as the next number state's exhibit after the Palm Beach County reports. That's a composite as well.
Those are case number 11. Oh, okay, and these are going to be 12.
Judge, that's all the testimony and evidence the state will be presenting at this
Okay.
hearing.
Can I see 11 and 12?
Yes, Judge.
Okay, so 12 was the FDLE reports.
Yes, Your Honor.
right, thanks, you can have those back. All right, I don't know how you want to have any argument, you want to submit that in writing, I don't know how you want to do this, I don't really care, it's 12:15, I'm assuming that some of you might want lunch. I'm assuming some of you want to return to Palm Beach County or Jacksonville or whatever that may be, so I'm game, whatever you want to do.
May we talk for a second?
Sure.
So you want to-
I'll defer to the defense judge, whatever they want, however they want before.
Yes, Mr. Urbana, question.
Yeah, sure.
We're asking Mr. Urbana about a possible stipulation. On the point of evidence.
Okay.
Genetic genealogy. These are kind of
Sure.
analysts.
Hey, I'm still on board, but I got a question. For the genetic genealogy, send to use that was wrong. Okay, all right, because they're asking me to stipulate that. Okay. That's not stipulated. Judge, the defense has asked the state to stipulate where basically what unknown profile was sent to.
I thought that was established earlier.
I think
One witness said that it was the Daytona Beach Police Department.
that's what we're gonna stipulate.
Gunther, because I'm assuming that was the one that they were able to develop the full 21 loci on, which was the strongest sample.
Yes,
So
Judge.
that's my assumption, but that's just my general assumption, so.
It can be stipulated too then.
Okay.
But just to elaborate that it was, it was the profile developed from the oral swab of Laquetta Gunther, that was used to develop a SNP profile for the genetic genealogy. And did not come, that there was no SNP profile developed from the PDSO lab.
I don't know if I can say that the profile that was sent was Laquetta Gunther. Okay, that's what I can say, speaking with Detective Denard.
Okay.
The profile that was sent to Parabon and.
Yes.
Whatever we agree here doesn't
Sure.
have any worth of weight in Palm Beach County. So the judge down there can make a completely different finding based upon his, whatever evidence he sees. But from what I've seen in here, you're correct. The SNP profile came from Ms. Hunter's,
I think that's an important point for Mr. Shea and Mr. Hampson to make regarding that.
okay.
If we may, Robert, we did submit an answer to the
Right.
potential. I think we can sum up pretty quickly the evidence here. I think the issue is basically we would like to make oral arguments based on what the court has heard today. And I could be actually relatively brief because it really has to go with identification. It's the issue that the state is raising to try to bring in the Bay murder into the 3 homicides here.
Right.
Chris Anderson speaking here, second chair of defense counsel. Yes, sir, we prefer to just make a little short oral closing argument here rather than do it right.
Okay, you want to do it now or?
Yes, sir.
Okay, you ready to go?
Ready to go, Judge.
All right, it's their motion. They get to go first and last. Do you need a short break?
I'm fine, Your Honor.
Anybody need a short break?
No, sir.
All right, now, we'll try to be reasonable. We're not gonna starve anybody to death. So if any of you are like Fidel Castro and you're gonna speak for 3 hours, I'm gonna cut you off, okay?
Yes.
All right, Mr. Urbana, you get to go first and last.
Judge, and I'll be brief as well. I'm gonna primarily rely on.
I paid close attention to the evidence, so, you know, to the extent, don't need to repeat the whole evidence, just hit the highlights.
Yes, Judge, and I'm not gonna belabor the points made in my motion. I have some case law, but I'm just gonna give a copy to the defense, a copy to the court to review if the court chooses to. It's
Yeah,
case law cited in my motion, some additional Williams rule case law as well. Now, the state, we did file our motion under inextricably intertwined in Williams rule, but I think primarily, having heard the testimony and evidence, this is something that follows under similar fact evidence under Williams rule. And to be admissible as Williams rule evidence, the court has determined whether or not there's sufficient evidence that the defendant committed the collateral crime. As
you know, we don't need to hurry either though, because the court reporter will hate
Yes,
you
ma'am.
for that. So it's okay, take your time, but hurry up.
Staying with that, Your Honor, I would submit that the court did hear sufficient evidence that Mr. Hayes is the one who committed this collateral crime down in South Florida. There's DNA evidence not only on the genital swabs, but also DNA evidence on the top of the left hand, which I think is particularly important in this case, where it appears from the crime scene photos that the victim was dragged.
But the commission of the crime down there is not an issue. It's whether or not that crime should belong here,
Yes, Your Honor.
based upon the evidence.
Yes, Your Honor. And our argument is that it is, and that the collateral crime meets the similarity requirement, but the similarity requirement really is just about whether or not there's sufficient relevance for it to come. There's plenty of case law that I have provided to the court, and I will provide in cases where Williams rule evidence or collateral crime evidence wasn't similar, but it was still admissible because it was relevant. And in this case, we had that in some regards with how the investigations are intertwined. Because both these investigations, particularly the Daytona Beach ones, have been cold for 5-10 years based upon the testimony of Detective Denardi, and there were no significant leads, and nothing had happened on the case in years until they got this CODIS hit, which kicked things into high gear and led to multiple agencies working to use new resources and new technology to identify the person who left the DNA in these two places, the consistent DNA between the South Florida case and the Daytona case. So I think it's very relevant for that purpose to explain and show to the jury how this investigation progressed, how the agencies worked together, why they worked together. And even in light of that, there are significant similarities, and I point them out in my motion. I think I list off and talk about the similarities between the women themselves, the ages, the heights, the weights, the position that they're found in, the fact that they don't have any clothing, the fact that one I forgot to list in my motion is that there's no identification on any of the 4 victims. The ones at Daytona Beach, admittedly, there is personal possessions, but no IDs, no credit cards, no bank cards, nothing showing who these women were. All 4 women were also found, and I think this is particularly important, the location where they were found. They were found in secluded areas, yes, but they also weren't completely hidden. The 3 in Daytona Beach, for instance, the one found down on Beach Street, North Beach Street, was found between a building, but 20-30 yards beyond that building, as the court knows from the photographs, there's a small canal where she certainly could have been put instead of being left in the alleyway. The cases, the other 2 cases, the case out by Bayberry Lakes, the victim was found, again, in an area where there's not a lot of traffic in a construction zone, but again, she could have been even dragged farther away from where she was located, in an area where she wouldn't have been located, in a swampy area. And there's so many particular details such as that with these victims and with the locations of these crimes that are significantly similar. And I would submit to the court heighten the relevance for purposes of showing identity, that the same person committed the crimes here as in South Florida. But it's not just identity that this evidence goes to, Your Honor. It also goes to rebut defenses that could potentially be submitted by the defendant, particularly the defense if the defendant was to argue a trial that, as he admitted to in his interview, he does get prostitutes. 2016 using back pages. In the interview with Detective Denardi, he indicated that he would sometimes pay girls looking to get paid at clubs here in Daytona Beach. So there is certainly the possibility that the defense could be, yes, I get prostitutes, yes, my DNA's there, but I didn't do this, I didn't kill them. And I think evidence of an additional homicide in South Florida that's significantly similar with another prostitute where the defendant's DNA is recovered would rebut that argument. And one of the cases I'm going to give to the court, which is a very well-known, and again, won't use the word at trial, a serial killer case involving Eileen Warnos, was where the state was allowed to submit evidence to the court about her other homicides. And that was to rebut her argument at trial, which was more of a self-defense argument that she submitted in the trial of that case. So that case is in here, and we would submit the evidence as relevant for that purpose. And also to show intent and premeditation. And intent and premeditation is one thing in the case law where there does not have to be significant similarities. But in this case, there are significant similarities. So based upon the case law, the comparison, the identifiable similar points of all these crimes, we would argue that it's relevant, it's admissible, it's not stale because we're actually dealing with a crime that is more recent than our homicides. As the court heard, the testimony and evidence in relation to Rachel Bay is both DNA and also technological evidence as well, with tracking the defendant on his cell phone. And also the state would argue that it would not become a feature of the trial. We're dealing, as we sit now, with 3 homicide cases here that as of now are going to be tried together unless there's a motion to sever and the court grants that motion. The state would limit the testimony and evidence at trial related to Rachel Bay to the particular points we presented here to the court. Of course, we may have to present another witness or two to avoid hearsay issues. But when you look at all the evidence the court will hear in relation to our 3 homicides versus the evidence in that one single homicide from South Florida, the state does not believe that it will become a feature of the trial and would be willing to work within the confines of a court order to avoid that being an issue. And many appellate courts have looked at in other murder cases where the Williams rule evidence has been up to 3 days of testimony and has found that it did not become a feature of the trial. And I don't think we would reach a 3-day testimony threshold in this case, and we would be able to keep it from becoming a feature of the trial. So for those reasons, we would submit that the evidence is relevant, it's admissible, it's not overly prejudicial to the defendant in this case. That's all from the state.
All right, thank you. Mr. Sheriff Anderson, Mr. Anderson, gonna take the lead.
Your Honor, Mr. Hayes is not on trial in your Volusia County courtroom for the murder of Rachel Bay, which occurred in Volusia County.
In Palm Beach County.
Excuse me, Palm Beach County in South Florida. Completely different case. If it's going to come in at all, it's going to come in as so-called Williams rule or similar fact evidence, or as the state's motion argues, inextricably intertwined evidence. And it's none of the above, Your Honor. We know that evidence of collateral crimes or acts is admissible under section 90.402 Florida statutes, not because it's similar to the crime or act at issue, but because it is relevant to prove a material fact or issue in the instant case. In other words, it's admissible to prove an element of the state's case or to meet an anticipated defense, and that is in basic Williams versus State 110 Southern 2nd 654 case. That's the old Florida 1959 Williams case, the original one. If the similar fact evidence, of course, is relevant to prove only a bad character or propensity, it's not admissible. But before we go on and look at the individual facts of the case, there's an even bigger consideration. That's the weighing test. Under 90.403, the prejudicial effect of the proposed other crime evidence must not outweigh its probative value, and it can't deprive the defendant of his rights to be proven guilty beyond a reasonable doubt. In our Volusia County case, we got to be careful to make sure it does not function as a non-statutory aggravating circumstance in our Volusia County, Florida death penalty case. And a key consideration in making this determination of the probative value against prejudicial effect is the question of whether the strength of the other evidence available to the prosecution in our Volusia County case has available to it to prove the fact. And the case that says that, there's two of them, it's Huddleston versus US 485 US 681, that's a 1988 case, United States Supreme Court, and Florida Supreme Court case, Ruffin versus State, 397 Southern 2nd, 277. At pages 279 to 280, that's a Florida Supreme Court 1981 case. And so the question in determining whether the probative value outweighs the prejudicial effect is whether the state already has enough evidence to, in the Volusia County case, to prove without having to rely on the Rachel Bainberger evidence. And Your Honor, I would submit to you that there is plenty of evidence in this Volusia County case for the state to use to prove whatever it proposes to prove without having to resort to the Rachel Bay strangulation case down in West Palm Beach 10 years later and 200 miles away. The state says in its subject motion that it plans to use the evidence of the West Palm Beach strangulation murder of Rachel Bay in this Volusia County shooting murder case to prove motive and intent, common scheme or pattern of criminality, identity of the defendant, absence of mistake, rebuttal of anticipated defenses. Okay, first of all, as far as identification is concerned, it should be clear to Your Honor, and I think everybody else in this courtroom, that they do not need the Rachel Bay murder evidence to prove the identity of the defendant in this case. All the DNA that they relied on to identify this defendant came from up here in the Volusia County case, and that was immediately established by Detective Denardi when he said that the DNA came from the oral swab from victim number 1, Laquita Gunter, and also they indicated that they found the defendant's DNA in the I Want a Pat vaginal swab. And so even before any of this work was done in the Rachel Bay murder, they already had identified the defendant. So they don't need that for identification purposes. Quite frankly, I'm surprised the state has not said we withdraw the identification part of our motion because they don't need it. They've got plenty of evidence without having to resort to that. I'm just skimming for the highlights, Your Honor.
Yeah.
Detective Denardi said it's his understanding as lead detective that the male DNA collected from Volusia County murder victims Laquita Gunter and I Want a Pat matched the DNA collected from the South Florida beer can at cigarette. Thomas Youngman of the Daytona Beach PD testified about victim Laquita Gunter being wedged into an alleyway between two buildings with a gunshot wound, which is very significant because the other murder sites that we saw here today were in open areas, grassy fields near a road, out in a meadow that was not visible from the road. All of them were different. We heard Ms. Florence Hayes, the defendant's mom, testify that he never gave her a gun. So what? I don't understand that. That's a collateral matter, right? Again, the question is, should the Rachel Bay murder evidence be admitted up in our Volusia County case? The testimony of Mr. Fulcher, the medical examiner, Laquita Gunter died from a gunshot wound to the back of her head. Number 2 up, also second up here in Volusia County, Julie Green died from a gunshot wound to the back of her head. Victim number 3, I Want a Pat, death from a gunshot wound to the front, to the face. Victim number 4, Rachel Bay, down south, where death from strangulation, completely different. The other factors, the body weights of the victims are all about the same. The race insignificant. We had 2 black victims, 2 white victims. We had prostitutes with intoxicants in their blood in all these victims, but of course, Mr. Fulcher testified that about 50% of all prostitutes that the medical examiner does autopsies on are found to have some form of intoxicants in their blood. And again, we also have Julian White, the state's DNA expert, indicating that it was the Iwana patent vaginal swab DNA that up here in the North Florida murder case that resulted in the match to the defendant. In other words, we don't need any more DNA from any more victims to be able to identify Robert Hayes as a source of the male DNA found in our Volusia County victims. And this is according to the state's own.
Since you're going to the evidence, I thought one of the DNA samples was very low statistical value, it was 1 in 25,000. So, I mean, I know what you're saying, that definitely as victim number 1, it was very strong DNA, but I think that's one of the victims that was very low statistical value.
I believe so, but the point I was trying to make, Your Honor, is the identification of the defendant was based on Volusia County DNA, not Rachel-based DNA. It had nothing to do with it. We had Mr. James Evans' Palm Beach County cell phone tracking information. And what those blogs showed, Your Honor, were the signal propagation zones of the cell tower. And those blobs didn't move around much. I don't know what that shows. I would submit that that's not really dispositive of anything. It was just such a huge area, and there's very little movement in those blobs. So I don't believe the court should really put any weight into that. The video recorded interview of the defendant himself, that he lived in the area, there's no dispute about that. That he resorted to prostitutes frequently. There's no secret or no surprises there. As for Stacie Brenner and Melinda Sowards, their testimony really does not add anything to what we already have. I did provide the court with an outline of really undisputed facts so that the court could easily compare the various victims. And I'm not going to read through them all again, but I've highlighted some in yellow. And I'm just going to touch on those real quickly here if I can. The Laquita Gunther murder, the location of the victim's body wedged between two buildings, race white. Laquita Gunther was found naked, face down with white socks on her feet, with a gunshot wound to the back of her head. And as for DNA expert, it is again Laquita Gunther and I want to patent 2 Volusia County victims that the state has indicated led it to identify the defendant. Nothing down in South Florida for identification purposes. The location of the victim, now I'm switching to Julie Green. Julie Green's body is found in an open area, not wedged between buildings. As with all the other victims, average build, nothing distinct or significant there. No socks on her feet. And a cause of death, a single shot to the back of her head. And we know that Ms. Green is really no importance or significance for DNA identification because the state did not obtain any DNA evidence from her, according to Detective Denardi. Ms. Green had no socks on her feet. I want a patent, again, found in an open area, race black, again, build average 143 pounds, nothing exceptional there. She was found naked with white socks, and she was shot in the front of her head with a bullet entering by the nostril and entering the other way. So the shooting direction's different there. And what do we know about the Palm Beach County murder? Rachel Bay, we know that average height, 5'6", average weight, 138 pounds. She's African American. No socks on her feet. So really, we don't have any remarkable distinguishing facts that really link the Rachel Bay murder to the 3 Volusia County murders. I want to talk a moment about Williams Rule evidence. And if the state intends to use the Rachel Bay murder to prove common modus operandi or mythology, then they must show a striking similarity to the murders. And there is no striking similarity. Murders are strikingly dissimilar. Shooting murders versus strangulation murder, Volusia County versus Palm Beach County, 2005 and 6. Yeah, they're 10 years apart. 10 years apart. Geographically tremendously different. And if there are striking dissimilarities between the crimes charged, as there are here with the Palm Beach County strangulation murder of Rachel Bay, then the collateral crime evidence, in this case Rachel Bay evidence, is not admissible. And the states I've cited for that are Newby versus State and Jones versus State. Very important cases. And when we talk about inextricably intertwined evidence, Your Honor, I heard the state indicate earlier that did not really apply, but then I heard it come back up in conversation. The state's closing, so I'll address it. Inextricably intertwined evidence and Williams Rule similar fact evidence are mutually exclusive concepts. They're either one or the other. You can't have one bit of evidence be both. And the case cited for that is Berry versus State, 264 7th 3rd at 1166. That's a Florida First DCA 2019, relatively recent decision. In the present case, the Rachel Bay murder occurred 10 years after our 3 Volusia County murders. The facts of the Rachel Bay murder are not in any way intertwined with the facts of our Volusia County murders. They're completely separate. The state cited a number of inextricably intertwined cases involving things like a crime spree, or cases involving a domestic dispute that escalates steadily and slowly upward. But this case has nothing to do with it. The 3 Volusia County cases are completely separate, disjointed, and in no way interlocking with the murders in the 2 different areas. It's just no inextricably intertwined thing happening there. Getting into the weighing test, the court always has to do the 90.403 weighing of the probative value of the evidence versus its prejudicial effect. In this case, the probative value of the Rachel Bay murder is negligible. In fact, it's non-existent because it's not needed for anything in this case. In our 3 Volusia County murders, as I have already indicated. But the prejudicial effect is tremendous. First of all, the state to introduce other crime evidence into evidence in our case only has to lay a foundation of clear and convincing evidence. It's not beyond a reasonable doubt. This defendant is on trial in West Palm Beach for the murder of Rachel Bay. And in West Palm Beach, where that Rachel Bay case is and should be tried, the state has to prove him guilty beyond a reasonable doubt. If the court were to allow the Rachel Bay murder evidence in this case, and let it in just based on the low Williams rule, clear and convincing evidence standard, it would increase the likelihood of conviction and death penalty here. And it would bypass and circumvent his right to be proven beyond a reasonable doubt of the Rachel Bay murder down there. It's extremely damaging, extremely dangerous, extremely prejudicial. We know that there's a huge body of case law that says that strangulation murders are heinous, atrocious, and cruel. That is one of the strongest aggravating circumstances for the imposition of the death penalty. And if the West Palm Beach jurors believed that he strangled Rachel Bay and that especially heinous, atrocious, or cruel aggravator thus applies to warrant the death penalty, then that should occur down there in West Palm Beach. It shouldn't happen up here. In fact, on the contrary, the murders here are all gunshot wounds to the back of the head, it looks like. There's no indication of torturousness, a prolonged desire to inflict suffering on the victim, which the case law indicates exists in strangling murders. So the prejudicial damage is tremendous. I would urge the court to apply that Wayne test and exclude all evidence of the Rachel Bay murder up in this 3-victim case here in Volusia County.
Thank you. Anything else?
I just want to talk about one point that was made by the defense.
Sure.
And that was about identity, arguing that it's not relevant because we have so much evidence of identity in our 3 cases. The defense brought it out, I think it was on the cross-examination of Jillian White, about how long DNA can persist in a person. Vaginal swabs DNA or in the vagina, DNA can persist for up to 72 hours. After 72 hours, they don't expect to see it anymore. On oral swabs, it can persist for 3 to 6 hours. After that length of time, you might not expect to see it anymore, depending on the content or the quality of the DNA, the amount of the DNA. So what the state could show in this case, and it's technically circumstantial evidence, is that, for instance, Laquetta Gunther, she was murdered, she was found dead. And 3 to 6 hours before she died, this defendant had contact with her. By having the testimony and evidence regarding Rachel Bay, where it's not just DNA that's recovered from her genital swabs, but DNA on her hand in a situation where she was clearly dragged, already dead and naked, murdered to a location in a case that's significantly similar with how she's left, the type of person she is, the type of target she was for the defendant. That significantly strengthens our argument to say not only does this 3 to 6 hour window, we can say that this defendant had contact with this woman, but this defendant killed this woman, just like he killed Rachel Bay and then dragged her out into the middle of nowhere from his car. So I would submit to the court that, yes, we have evidence in the Volusia County cases, 2 of the cases, to show that this defendant had contact with these dead women, but having that evidence with the DNA on the hands significantly strengthens the state's case in terms of identifying Mr. Hayes not only as having contact with these women, but being the killer of these women.
Well, before you sit down, I think the defense makes a very good point in that strangulation deaths, they certainly take a heightened step on the death penalty. I mean, not only legally, but factually. And hearing the testimony of a strangulation death from a medical examiner is very impactful versus gunshot wound to the back of the head, gunshot wound to the front of the head. That is concerning if you are going for the death penalty and these jurors hear that Ms. Bay was strangled to death, and arguably because you're gonna say he got rid of the gun, so he got nothing to shoot her with. That would make a big difference in whether or not the juror should even hear that, because I think they may just be swayed on the death penalty issue, on the side of voting for death based upon, as counsel said, a hack aggravator that is not here for their consideration on a murder that it didn't happen here. So that is very concerning to me. So
I understand the court's concern. I think that could be addressed with perhaps a special jury instruction or
that's a
curtailing,
big bell. That's a third rail.
or curtailing the state's evidence to limit how much we can go into potentially the manner and all the cause of death in that homicide.
I suppose I have to look into it, and if you want to get me something, whether or not I can parse out or limit how much I would allow from the Bay murder into this case, based upon what we have.
I think the court has that authority to limit the state and how much we can present to avoid it from becoming a feature of the trial.
Having said that, the Warnos case was a local case, by the way, that happened here, and they made a movie out of that. I was not in the movie, I want to be clear on that. So, okay, all right, so I'll get you an order as quickly as I can. I have another death penalty order I gotta get out, but I'll get you one soon, okay?
And Your Honor, before we,
Mr. Hayes,
That was it.
are you sure you wish to speak, Mr. Hayes?
I was asking for permission to speak.
Do you think this is wise with your lawyers advising you not to do that, Mr. Hayes?
All right.
I would ask him not to.
Well, he's gonna follow advice to say that.
I do want to say something. It's very important that sometimes his feelings and thoughts be placed on the record outside the presence of the state. I do want to give him that opportunity if he wants to speak somewhat privately. It will be on the record, but it will be with your lawyers present and your lawyers present only. Okay? So if you want to speak, let me know, and then I'll try to make those arrangements so that the conversation can exclude the state.
Judge, what I was gonna say is, I know we're set for our trial date in January.
You need to plan for it.
Assistant State Attorney Jason Lewis is gonna be trying the case with me, and I see he's on, I don't know if he's actually on Zoom or if he's just there. I know his name's there. And we were gonna ask to have it bumped just to February, to help accommodate Mr. Lewis. He's got some commitments in January that I wasn't aware of when we agreed to the January date, and I hadn't brought him on to assist me yet in the case.
I don't think I'll be able to do, I mean, I have to look, but I want to keep things on track,
Very well, Judge.
okay? Because that not only impacts, this case, it impacts South Florida case too, so. All right,
Yes, Your Honor.
I thank you all very much.
Thank you, Ed.
Could we perhaps with the court, contact your deputies, if we could speak with Mr. Hayes back.
You have to do it downstairs,
Okay.
downstairs, first floor.
Can you hold him downstairs?
Yes.
Okay, we'll meet down.
Type this up.
I know it sometimes it would be, at some point it definitely will be. I don't know how it gets ordered. Usually more towards the end of
Yeah.
the trial, but that would be up to the. Probably do it in a week.
Week?
Yeah,
I'm able to order it.
okay.
Yeah.
Good, are we finished on Zoom?
Oh, yeah, let me end the meeting.